Welcome to this presentation, HMRC Tax Advisor Registration, where we are now and emerging issues. This is a short update for residential conveyances, and we're going to look at a range of issues that have arisen as a result of recent guidance from HMRC, including some key elements of the Finance Act of 2026. We start off by looking at the issue of the Finance Act. And broadly, the relevant provisions of the Finance Act 2026 now require anyone meeting an extended definition of a tax advisor to be registered with HMRC. The registration window started on 18th May 2026 and runs for 3 months. And at today's date, this recording is being done on the 7th of July. In broad terms, an organisation or sole trader is a tax advisor under these provisions if in the course of business they assist another person with their tax affairs, for example by acting as the other person's tax agent or assisting them in completing their tax return. So it's a fairly broad definition. Now, the key point is, starting off, is looking at the application for registration, which is dealt with under section 225. A person wishing to register as a tax advisor must apply to HMRC for registration. And applications must be made in the form and manner specified by HMRC and using procedures published by HMRC. So the legislation delegates to HMRC the practical registration procedures and also anything else to do with the administrative guidance, which we'll refer to as we go through this presentation. Section 226 of the Act also introduces the concept of a relevant individual. A relevant individual primarily is someone who plays a significant role in deciding how the organisation tax advisor activities are managed or organised, or actually manages or organises the whole or substantial part of those activities. But as we will see, in certain cases, the category is expanded depending on the number of officers in the organisation. So the tax advisor registration must primarily be done by the business entity, whereas relevant individuals linked to that entity and registered with that entity must be put forward for registration in accordance with what the Act says. And if we look at the next slide, what this shows is that a distinction in the legislation is drawn between smaller organisations with 5 or fewer officers and organisations with 6 officers or more. So in the case of an advisor organisation with 5 officers or fewer, all officers automatically count as relevant individuals, whether or not they are personally involved in tax advisory activities.